What's going on? Today's question is, can I get a green card through my stepchild? Friends, welcome to Green Card Guys TV. I'm your host, John Ting, helping you solve your immigration problem and maybe even prevent it from happening in the first place. Okay, folks, sorry for the slight delay. I just got back from, as you can see, my hair is a little up here because I've been went outside today. Went to the USCIS field office here in Houston, Texas, and represented a married client for an interview. And you might wonder, why is there an interview, John? Because you've been talking about USCIS waiving interviews. So we'll talk about it a bit later, but I can tell you it's on the right track. Okay. But today's topic is, can I get a green card through my stepchild? And yes, you can. Now, there's a couple things that want to make sure that keep you eligible for that. Now, by the way, of course, if you are new to the channel, I just want to share a couple things. Is that number one, we do offer free 15-minute preliminary discussion. Just see if we can point you in the right direction. There's no pressure to, sign up with us or anything like that. We're not about that. We just want to make sure that if you did need legal help, that you at least consider us, because we're very, very intentional about customer service, and which it really includes making sure that you receive the updates timely. Now, I'm actually going through a situation with my kids' school, and they're not as timely. They say they update us, but it's not timely. So that's not being transparent, right? So I think about my own personal situation also, not just about lawyers, okay, or legal situation. I always try to think about other situations, how that lack of or positive situation as a customer service, how that can help the law firm and you. All right. So, of course, if you have questions as well or just comments, you're welcome to drop it down below. But to answer this question of the day, can I get a green card through my stepchild? I believe I talked about this briefly the other day, but here's the deal. Number one, that you have to get married, okay, before your stepchild turns 18. That relationship, that stepchild relationship has to have occurred because of the marriage to the biological parent before that child turns 18. Now, of course, this is assuming that the child is a U.S. citizen by birth, or could have been through the automatic acquisition of U.S. citizenship. But most of the time, 99% of the time, it's through birth in the United States. The second thing you need to know is that, well, does that mean I have to file a petition? Does that mean I have to file a petition before the child turns 18? And no. In fact, actually, your child has to be 21 before the child files for you, okay? So that's very important. Your adult child, stepchild, has to be 21, who is a U.S. citizen, before they can file for you. So that's just a couple things. So it might be strange, like, okay, well, I have to do this, get married, because some of y'all have been living your life as partners, spouses, together for many years, but you're not legally married. Okay, so that's one of the, I realize that some of our calls the past 6 months, this question, this issue has come up more often. So that's why we want to come out today and share this topic and answer it. That's really the gist of it, really. So anyway, this is called immediate relative classification, which also means that the visa is hypothetically available immediately. Like, there's no wait time. You don't have to follow the visa bulletin chart F1 through 4, as long as you follow those steps were taken. Married before the child turns 18, and that you wait to file the petition as soon as that child turns 21 as a U.S. citizen, okay? I see a couple questions here. Now switch gears here to the questions. So, by the way, if you're just now joining, welcome to greencardguys.tv. You're welcome to type in a question in the comment section. Okay, Jamie, say anyway, CNAs, okay, certified nurses, I think that's what you mean, can get a green card. It is possible, but it really depends. If I recall, I think you're in the US already. So you have to, if you want to get residency here in the United States, you have to get, you have to maintain your status. Unless you qualify for an exception, which will not really be, relevant. I mean, it could be helpful, but not relevant to needing to get a residency through work. So you have to maintain status. So it could be through F1, student visa, any other non-immigrant visa. But most of y'all are watching and probably watching other shows, attorney profiles. Is not, most of y'all don't have not maintained status who are in the United States. So that's why we talk about situations where you could still qualify without maintaining status. Okay. Any other questions? Let's see. Hopefully that helps. I mean, that's just a brief response. Happy to answer any other questions. But in the meantime, let me just chat a little bit about today's my client's interview today. Of course, I'm not going to divulge anything that is going to just indicate that it's that person. But okay, let me just speak hypothetically then. So if you're in a situation where you have a second or third marriage with a U.S. citizen and you file for residency through that spouse, that's okay. That's permissible in general. They're not going to, USCIS is not going to reject your file if they see a petition, okay? Maybe it's like the third or fifth petition. Now, the thing is that you have to speak with a lawyer to review your immigration cases, the previous ones, because there could be a situation where you filed a petition with another spouse and you obtained residency. You were able to get that conditional resident status and got approved for it from the first or prior spouse, but then the problems start happening. You start having marital problems. Maybe your spouse started, cheating on you, and you didn't know it, and you found out because you're probably trying to figure out why are they not as, not lovey-dovey anymore, basically? Why are they not, being close to you, whatnot? So, or they're not just not communicating with you. So something's up, right? Even though you already got approved for the green card, and you're thinking, okay, great. I heard this lawyer say, or John Ting say, you can file a 751 waiver, right? And that is allowed. You can file 751 without your spouse who originally sponsored you. However, in some scenarios, people file 751, they hired a lawyer or they did it themselves and they accidentally checkmark married. File jointly. File jointly means kind of like a tax return, that it's based on your marriage together, still continued marriage. However, in this particular person's situation, they were separated. And most people think, because based on the instructions that USCIS provides to you on their website, it does mention that you need a divorce order. However, keep in mind, this is where lawyers come into play, okay, that have experience in these cases. We know that you don't have to literally have a divorce order at the time you file. It would be wonderful to have it, but you don't have to. You can still file your 751 waiver, meaning separated or divorced, and file that without the divorce order. Because some of y'all around that time period, because you have to file to remove the conditions 3 months before that conditional residence status expires, which would be at the 24-month mark. So between 21-month mark and 24 months, you have to file that application, 751. Okay, so by that time, that's maybe when you start getting separated, start having some marital problems. So you don't have a divorce order. And in most states, apparently, you have to be physically separated for a certain amount of time. In Texas, in where I'm at, Texas and a couple other states, you don't have to have that physical separation requirement, which is a great thing. In Texas, you can get divorced as soon as 60 days, 2 months. Okay. So, sorry, I had to shut the door. So in 2 months, Let's say you file a divorce for today. That's called petition for divorce in Texas. April 21st. So roughly speaking, May 21st will be, 30 days. So around, well, June doesn't have, around, let's say June 21st. Hypothetically, that's 60 days. The math might not be correct, but let's say June 21st, that's when you have a court hearing, get divorced. And as soon as that happens, we, as attorneys, our legal team, we provide a copy of that divorce order with your 751. We have USCIS update that file. Okay. So in this person's situation, they didn't have that. They sent an RFE asking for divorce order. Not going to state the years, but ended up being 2 years before the person got divorced officially. And you might wonder, why the heck did that happen? How come so-and-so, that person didn't get a divorce earlier, right? Why didn't they file it? Well, because most people who, when they call us, they think they need to know, they need to have that person's signature. Okay. They think they need to have an agreement. So that's why it's very important to speak with a divorce lawyer too. I mean, I'm licensed in Texas, so I know some divorces. We filed divorces before. We really try to limit that and really focus on immigration. And we help pro bono for people who have been what we call domestic violence survivors. But here's the deal. Okay, I mentioned 2 months, but some people assume you need to get the other person's signature. That's just to make it easier. And then a second thing people assume, a myth or misconception I want to break down, is that some people think, okay, well, I need to know that person's address. Yes, that would make it easier so you can serve them, by mail or hire a process server, someone that's like independent, neutral, basically. So yeah, it would be ideal to have the person's address. Okay, but let's say you don't have that. You can still file for divorce. Okay, there's like what we call service by posting or service by publication. There's just alternative ways, at least in Texas, to make it happen. Okay, so hey, if you don't know what other states are easier to get a divorce and you're living somewhere else, because you're all that are watching live in many other states in the United States, hey, and if you want to be able to get a divorce and you've just been waiting because the rules in your state are so restrictive, come on down to Texas. Many people who live in Texas don't want you to move here because when you buy a home, it's going to raise the prices. But hey, if you're trying to get divorced, not saying you get on a flight today, come in tomorrow, you file divorce. You got to meet certain requirements. How many days? I believe, 6 months. 6 months in Texas and 90 days residence in the county. Okay, before you can file for divorce. So, but anyways, we're pretty loosey goosey here in Texas, surprisingly, about our divorce rules. So, long story short, this hypothetical person filed for 751 twice. Most recently, I think in 2020, received another RFE, received another notice of intent to deny. And trying to make a long story short, is that which is difficult for this kind of case history. Got a letter, said denied. 751 case denied, not once but twice. Okay, and so my people, some people think, oh well, shoot, I'm done. No, you're not done. Don't worry. Okay, don't you worry. Okay, even though the denial letter will say conditional resident status terminated, it's not actually terminated. I know, it's strange. It's not actually terminated, even though it says that in the letter by USCIS. What happens is that your case is supposed to be referred to the Immigration Court, Executive Office of Immigration Review, EOIR, okay, for removal proceedings, deportation. But some people don't actually get their case referred to it. So the judge is the one that's supposed to determine the finality of your conditional resident status. So, for example, when we have an interview for this, subsequent marriage, they have the applicant sign a form saying, "Are you waiving that you're not going to challenge your conditional resident status was terminated before, and you want to move forward with this new case?" So the client signs it, and I explain it to the client. and they understand. And I explained it before we met up with the officer, just so they're not surprised, right? Because I always don't like when clients understand or don't understand what they're signing. It's very, very important that you understand what you're signing. Even our contracts, very important. Let's see. The other thing is that, that's a lot of information. So, but maybe I just kept talking because y'all don't have any questions. But you're always welcome to interrupt me, stop me there if you have any questions, even if it's not about this topic. Just want to share a positive experience recently on this hypothetical person. So it's good news. I-130 is approved. The only thing is, have to get an updated medical exam. It was just right around the time where the October 1st, 2021 USCIS required COVID vaccine to be included in the medical exam. And the client had actually got the medical exam completed 2 months before. So no problem. This happens. And the client is going to go back to the clinic today. This hypothetical person is going to go back to the medical clinic today to get that updated. All right. And so anyways, follow me on TikTok, actually, because I'll share a little bit more about this hypothetical situation, especially with this situation about 2 applications of 751, and those were denied. He had an opportunity to provide more information, and one of them he did, another one he didn't. So, yeah, I'm happy to share more. Stay tuned for that. So on TikTok, by the way, if you're interested, if you have TikTok already, if you don't worry about it. But if you happen to be on it, it's at @greencardguys_John. I greatly appreciate it if you give me a follow and check out the news and tips there. It'll go a little bit nugget size on there. Alrighty. I see a question here. So anyway, just want to share that positive experience hypothetically today. Okay, Diana, you said, thank you for this live. You're welcome. Happy to share information. How long does it take for prosecutorial discretion request? Your lawyer submitted a request more than a year ago. Okay, so yeah, I mean, the government attorney, to answer your question as directly as possible. If your case is active, meaning like your court hearing could be coming up like next week, then Department of Homeland Security, those attorneys are going to prioritize those cases. If your case is closed, administratively closed, or order removed, they're 99.9% of the time, Department of Homeland Security, unfortunately, at this time, currently, is holding back, okay? Because from what we've been told and what we've noticed is that they're waiting for the Supreme Court case, okay? It was already had arguments, okay, live arguments already. So it's April 21st. Usually when the arguments are completed, they don't give the decision on the spot, okay? They need time to review it and issue a decision, and that comes out in June. That usually comes out in June. Like every day there's a new decision coming out. Like last year, one of the hot topics of SCOTUS, Supreme Court of United States, was about abortion when they overturned Roe versus Wade, which personally I think is ridiculous. Who would have thought that a case like Roe versus Wade would have been overturned? I can make another channel just about Supreme Court, but okay, you said so. If you have withholding and removal, thanks for sharing that. And you want to adjust that to your U.S. citizen spouse. And so I'm assuming you already filed the petition at least. And what we usually advise clients is that don't file the 485 application yet, because that's going to get administratively closed. I mean, you could file it, but then, file before the USCIS fees get increased, potentially sometime this summer, I suspect. I thought it would have happened already by now, but that's another episode. But at least a petition. But even when you have a petition on file, I mean, that, first of all, that's what the government attorneys want to see at least. But yeah, since you said you have withholding and removal already, your case was approved for that, they're not going to. There's no hurry for them. Okay, so we're for us personally, our Ting Law Group, we're trying to do better to advise as timely as possible these new things about, especially about prosecutorial discretion, because yeah, the department DHS is holding out. But if it's an active case, let's say, Diana, that you had an active case, we have a court hearing coming up soon, then I just had one a couple weeks ago, actually in April, and we sent emails about it at least 3 to 5 times, and it's not like we send it every week, but probably once every couple months. It was assigned to a attorney, a DHS attorney. No response after that. And then, you know what? We're just like, okay, whatever. I mean, at this point, we're just going to show up in court, have the packet of evidence ready about the marriage, and boom, judge dismissed it. I was like, I wish it was that easy. I wish I could just email the judge and ask for a decision. But typically, the reason why some attorneys might not just file a motion directly to a judge is because judge, especially when if your case is active like this, then yeah, I mean, we would go ahead and just file the motion. But our court hearing was coming up soon anyway, so we one figure would just show up, right? And the client lived in the Houston area, so it worked out. But if a situation where like you live in a different city now than where your court case is located, then we would consider filing that motion. If your case is active. If your case is not active and you have order removal, then you're only allowed by law one chance at filing a motion to reopen. So this is why our team, and I'm sure most other lawyers who help with this PD request, is that we really, really recommend getting the Department of Homeland Security on our side, okay, to negotiate with them, to explain to them. But the other thing is like just getting them on the freaking phone. Okay, that's difficult. All right. So I'm sorry that you have a delay, Diana. You're not the only one. We have a couple clients in your similar situation. So please hang in there. Okay. Hopefully we'll get a better idea or hopefully Department of Homeland Security knows what they're going to do by maybe mid-June or end of June. Okay. Okay, folks. Thank you so much. Anu, I see your question. I forgot. I got a 12:30 appointment Central. Someone just reminded me. One of my team members. Okay. But thank you so much. No, anytime, Diane. And by the way, folks, if you got any value from anything I shared, or not just today, in the past, please share your feedback. Go to reviewtinglaw.com. I greatly appreciate it. All right, Anu, sorry. I'll catch you on a next show next week. Okay. Y'all have a great day. Take care. Bye-bye.